Hi everyone, and welcome to Nova Real Estate Solutions. I'm Dwight Morris, certified probate and estate specialist at Innovation Properties in Fairfax, Virginia. If you've recently lost a loved one or are simply planning for the future, you've probably heard the term probate. But what exactly is probate, and why is it necessary in Virginia? In today's video, I'm going to walk you through the probate process in Virginia, step by step. I'll cover everything from understanding probate to common challenges, and I'll share a few tips for executors and administrators to help make the process smoother. Without probate, legally transferring assets like real estate or substantial bank accounts can be incredibly difficult, often impossible. It ensures a clear legal title for new owners and protects both creditors and beneficiaries. And even if there's no will, Virginia's intestacy laws dictate how assets are distributed, and probate is the mechanism to ensure those laws are followed. I went through probate with my mother's estate in Illinois a few years ago. And I quickly decided that the best thing I could do was to hire a good probate attorney. While it cost me some money, I never regretted it for one moment. The attorney obviously brought his expertise, but he also brought me peace of mind in a turbulent time. He handled the complex legal filings, the deadlines, and the communication with various parties, freeing me to focus on grieving and supporting my family. That relief was invaluable. While the initial cost of an attorney might seem significant, consider it an investment. Mistakes in probate can lead to much larger financial penalties, prolonged court battles, or even personal liability for the executor. So what exactly is probate? Let's start with the basics. Probate is simply the legal process through which a deceased person's estate is administered. This means verifying the deceased's will, paying their debts, and distributing their assets according to their wishes, or if there is no will, according to state law. In Virginia, probate is necessary to ensure that the decedent's estate is handled both legally and fairly. Administering an estate involves several key responsibilities: identifying and gathering all of the deceased's assets, paying off any legitimate debts and taxes, and finally, distributing what remains to the rightful heirs or beneficiaries. It's a structured process designed to ensure fairness and adherence to the law. If there is no will, Virginia has specific laws known as intestacy laws that determine who inherits. These laws are designed to provide a default distribution plan, typically prioritizing spouses and children, then other close relatives. It ensures that debts are settled and that property and assets are properly distributed to the heirs and beneficiaries. Let's walk through the probate process step by step. Here's how it typically works in Virginia. First, you need to open the estate. If there's a will, the person named in that will as the executor needs to file Circuit Court Form 1650 with the Circuit Court in the county where the decedent lived. It's important to remember that each county clerk's office may have slightly different local procedures, so it's always a good idea to check their specific requirements or website beforehand. Form CC 1650 is the starting point, officially called the Probate Information Form. It's crucial to fill this out accurately. This form requests that the court open the estate and admit the will to probate. If there is no will, Form CC 1650 needs to be filed by the person requesting to be appointed administrator of the estate. If no one steps forward, the court will appoint an administrator. If no one named in the will, or no family member is willing or able to serve, or if there's a dispute, the court will appoint an administrator who is completely independent of the family. This is often a professional fiduciary or an attorney, and this process can add time and cost to the estate settlement. It's usually preferable for a family member to take on this role if possible and appropriate. Again, the death certificate must be filed along with a petition as proof of death. The death certificate is not just proof of death, but it also provides vital information needed for the probate process, such as the full legal name of the deceased, date of death, and last known address. It's a fundamental document required at the very beginning. If the deceased left a will, it must also be filed with the court along with a petition for probate. Once the personal representative has been named, and that's either the executor named in the will or an administrator if there isn't a will, a notice of appointment will be filed, formally notifying any interested parties that the estate has been opened as part of probate. These interested parties typically include the beneficiaries named in the will, legal heirs if there is no will, and potentially known creditors. This notification serves as a formal heads up that the administration of the estate has begun, allowing them to take appropriate action, such as filing a claim if they are a creditor. The executor or administrator will need to obtain a taxpayer ID from the Internal Revenue Service and open a bank account in the name of the estate. The employer identification number, known as the EIN, for the estate is like a social security number for the estate itself. It's critical for tax purposes, allowing the state to file its own income tax returns if needed, and to properly manage financial transactions. The dedicated estate bank account keeps the deceased assets separate from the personal representative's funds, which is vital for clear accounting and avoiding commingling issues. Next, once the personal representative has been named, the estate officially opened, and the will admitted to probate, the personal representative must make an inventory of the deceased's assets, including real estate, bank accounts, and personal property. This inventory must be filed with the court on Form CC 1670 within 4 months of opening the estate. This inventory isn't just a list, it's a comprehensive valuation. For real estate, you'll need professional appraisals. For bank accounts, you will need bank statements from the date of death. Personal property can include everything from vehicles and jewelry to furniture and collectibles. It's crucial to be thorough, as this inventory forms the basis for distributing assets and assessing any estate taxes. You'll need to determine if assets are solely owned, jointly owned with rights of survivorship, or part of a trust, as this impacts whether they go through probate at all. The 4-month deadline for filing Form CC 1670, the inventory for decedent's estate, is a strict one. Delays can lead to complications or even penalties from the court. Third, Virginia law requires the personal representative to notify creditors of the decedent's passing. This is usually done through a notice published in a local newspaper. This publication, often called a notice to creditors, is a legal requirement. It typically runs for several weeks in a newspaper of general circulation in the county where the probate is taking place. This public notice triggers a specific time frame, generally 6 months from the time they are notified of the death, during which creditors must file their claims against the estate. If they don't file within this period, their claims can be barred. When a claim is filed, the personal representative must verify its legitimacy. This involves checking if the debt is valid, the amount is correct, and if it was incurred by the deceased. Sometimes negotiation with creditors is possible if the estate's funds are limited. Once the creditors are known, the next step is to settle the debts and taxes owed by the estate, and the personal representative will use the estate funds to pay off any debts, including credit cards, loans, and taxes. If the estate doesn't have enough assets to pay the debts, Virginia law dictates how those debts should be prioritized. And Virginia law has a strict order of priority for paying debts if the estate is insolvent, meaning there aren't enough assets to cover all the debts. Generally, funeral expenses are paid first, then administration costs of the estate, followed by certain taxes, medical expenses from the last illness, and then general unsecured debts like credit cards. Understanding this hierarchy is absolutely critical, as paying debts out of order may leave the personal representative personally liable. Beyond credit cards and loans, remember estate taxes and income taxes. There could be federal estate tax, though that only applies to very large estates, and also state and federal income taxes for the deceased up to the date of death, and for the estate itself during administration. Once the personal representative has reviewed the claims and settled all debts, they must file an affidavit attesting that all debts and taxes have been paid. Again, the personal representative must file a form, the Account for Decedent's Estate, Form CC 1680. This form, known as the Account of Decedent's Estate, is essentially a detailed financial ledger of everything that has happened with the estate's money since it was opened. It's where the personal representative reports all income received by the estate, all expenses paid, including debts and administrative costs, and how remaining assets are proposed to be distributed. This account must be filed with the Commissioner of Accounts, a judicial officer appointed by the Circuit Court, who reviews and approves the account. This oversight ensures transparency and proper management of the estate's finances before any final distributions are made. Only then can the executor distribute the remaining assets to the beneficiaries as outlined in the will, or according to Virginia's laws if there is no will. Sometimes assets aren't easily divisible, or beneficiaries might prefer a different distribution than outlined in the will. These situations require careful communication and sometimes formal agreements among beneficiaries. Finally, to close the estate, the executor or administrator will file Form CC 1681, otherwise known as the Statement in lieu of Settlement of Account. This form is filed with the Commissioner of Accounts and ultimately helps the court formally discharge the personal representative from their duties, concluding the probate process. Once this form is approved and filed, the personal representative is typically discharged from their duties and the estate is legally closed. This brings finality to the process. At this point, you may be thinking, well, that sounds fairly straightforward. It's a lot of work, but what could go wrong? Well, probate is not always smooth sailing. Disagreements between family members can slow the process down. Disagreements can range from challenges to the validity of the will itself to disputes over how assets are valued or divided. These can escalate into costly and lengthy legal battles. While open communication is key, sometimes formal mediation or even court intervention is required. This is where the value of a probate attorney becomes even more apparent. They can act as a neutral third party and navigate complex legal arguments. If one or more heirs contested the will or disagreements over asset distribution arise, the court may need to intervene. The best way to avoid this is by keeping open lines of communication and considering mediation if conflicts arise. Sometimes the estate doesn't have enough funds to cover all the debts. This is obviously a distressing situation. Beyond not having enough to pay debts, it can also mean there aren't enough liquid assets, like cash in the bank, to cover expenses. The personal representative might need to consider selling assets, even real estate, to satisfy the debts. This can be emotionally difficult, especially if the beneficiary is expected to inherit those specific assets. In Virginia, debts are prioritized, and the executor needs to follow strict guidelines on how to manage these claims. Working closely with an attorney and financial professional can help ensure that everything is handled properly. Delays in paperwork or court hearings are common, especially in complex estates. It's essential to stay organized and follow up regularly with the court. Court dockets are often busy, and even minor errors in paperwork can lead to resubmissions and significant delays. External factors like the complexity of assets, locating different heirs, or dealing with out-of-state property can also extend the timeline. A probate attorney is invaluable here because they understand the nuances of the court system, can anticipate potential bottlenecks, and ensure that all filings are correct the first time. Being a personal representative can be overwhelming, but with the right approach, it doesn't have to be. Beyond the legal and financial aspects, being a personal representative carries a heavy emotional burden, especially when you're grieving yourself. It's a role that demands meticulous attention to detail during the time of significant personal stress. Recognizing this and building a support team is vital. Here are a few tips to help streamline the process. First, stay organized. Keep all documents, forms, and records in one place. This will save you time and help avoid mistakes. Beyond a physical folder, consider using digital tools for organization. Scan important documents. Use spreadsheets to track expenses and assets, and maintain a clear log of all communications. This level of meticulous record keeping is not just helpful, it's often legally required for the accounting process. Reach out to creditors promptly to resolve any claims. Addressing creditor claims promptly helps manage the estate's liabilities efficiently and avoids potential legal action against the estate. Be sure to keep beneficiaries updated on the status of the estate. Regular, transparent communication with beneficiaries can prevent misunderstandings and disputes. Proactive updates, even small ones, build trust. Don't hesitate to work with an attorney, accountant, or real estate expert. Their guidance can save you time and ensure everything is done correctly. A probate attorney is your primary guide through the legal labyrinth. An accountant or tax professional is crucial for managing estate income taxes and ensuring all final tax obligations are met. If real estate is involved, a real estate agent specializing in probate sales can offer invaluable advice on valuation and selling that are unique to estate properties. Depending on the assets, you might even need an appraiser for valuation or a financial advisor for complex investments. Building a team of experts is an investment that minimizes risk and streamlines the process. And be patient. Remember, probate can take months or even more than a year, depending on the complexity of the estate. Probate is rarely a fast process. Managing your expectations and understanding that this is a marathon, not a sprint, will reduce your stress significantly. I hope today's video gave you a clearer picture of the probate process in Virginia. If you found this information helpful, please like this video, subscribe to this channel, and turn on notifications for more helpful content on real estate, estate planning, and probate. If you have any questions or need help navigating probate, drop a comment below or reach out to me directly. My contact information is in the video description. I'm here to help. I'll see you in the next video.